The employment agreement forms the core of the employment relationship, and they will typically address many different aspects of that employment relationship, from what the person's duties will be to how much they're paid, and will likely also address what they may or may not be entitled to on termination, as well as other clauses like restrictive covenants, such as a non-solicit, that the employer may want to rely on after the end of the employment relationship. What employers also want to turn their minds to is which of their policies will be included in the contract, either directly in the contract or perhaps as an addendum to that contract, and which will be included in different documents such as an employee handbook. In any given workplace, you'll have a wide variety of policies, particularly where you have an employee handbook. They can number in the hundreds of pages. It's simply not possible to include all of that in your employment contract, even though that handbook should be provided to the employee when they start their employment. But for the contract itself, you want to give some serious thought to which of your policies are more important and do need to be included in that document. The reason you want to do this is if the policy has been brought to the employee's attention, particularly at the start of their employment, it's far more likely that you'll be able to rely on that policy down the road and when found to be enforceable in court should you need to go down that path at some point. If the policy is buried in the handbook that the employee may or may not have read at some point, you'll have a more difficult time enforcing that policy regardless of how well it's drafted. So we certainly recommend that employers give this some serious thought, and they can reach out to us to seek advice about this and any other issues or questions they may have when it comes to drafting their employment agreements.